Are all accidents truly accidents, mishaps? Or are they the culmination of a series of negligent acts, from ordinary negligence to willful misconduct? What about natural disasters? How much of the disaster is attributable to Mother Nature, vice actions we have undertaken as a society? Are the resulting harms a consequence of a normalization of deviance? Welcome to Brungart Law's Lagniappe, wherein we provide you a little extra perspective beyond the law through conversations with individuals from all walks of life. I'm Maurice Brungart, your host. I enjoy engaging with experienced, knowledgeable, and passionate individuals for the opportunity it affords to broaden and deepen understanding of the world through their perspectives. They offer insights into what makes for effective practices and policies, enabling productive decision-making in our own lives. The more we learn, the more likely we can avoid common pitfalls, become better versions of ourselves, and guide others towards the same. Today's guest that we'll be learning from is Professor Blaine LeCesne. Professor LeCesne transforms students into advocates at Loyola University, New Orleans College of Law, where he has taught since 1991, and he's also an associate dean. Professor LeCesne has authored various works in the fields of torts and Louisiana civil procedure. Welcome to the program, Professor.
Thank you for having me.
Well, again, like I say to all my guests, it's a privilege. I'm grateful for this opportunity to engage in a conversation with you, and hopefully our listeners can derive some benefit from it. Why don't you tell us a little bit about yourself, where you're originally from, where you studied?
Sure. I was born in New Orleans, Louisiana, where I spent most of my young formative years. Attended Jesuit High School here in New Orleans.
Jesuit? What? I had no idea. I'm a Jesuit grad too. So
well,
what year?
As you know, Jesuits are very good at education, and so Jesuit High School was the preeminent high school here. I think it's one of the best in the country, and so I was very fortunate to be able to attend Jesuit High School. So I spent my early years here up to age 18. And then it was time to leave New Orleans, my beloved New Orleans, which is hard to do. And so I knew I wanted to get educated, college and beyond, in New York City. The reason for that is New York, to my mind, had the best of everything. So I wanted exposure to the best of everything, whether it was the arts or the law or justice or food. I'm a big foodie, or just life in general. It sort of gave me a barometer against which to measure any later endeavors in life, whatever they may be. So it was New York City. I was just determined to get there. And so I was fortunate enough to get into Columbia College, where I went to undergrad, majored in political science, and then from there, Columbia Law School. And so after Columbia Law School, I practiced at one of the larger New York Wall Street firms for a few years, and then moved to another Wall Street type law firm, huge law firms for the time. 200, 300 plus lawyers. By today's standards, that's a relatively small firm. Well, I should say medium firm, because firms today can, get upwards of 500 to even 1,000 lawyers. But at the time, these were considered the preeminent, blue chip firms. And so again, I decided to immerse myself in that world to learn from the best. And again, to set a standard for myself in terms of work product and lawyering skills, because these law firms had some pretty, excellent lawyers, and I wanted that training. So from there, I worked in New York at those firms for about 6 or 7 years, but then the pull of New Orleans. And you should know this well.
I do.
Having grown up in New Orleans.
It's hard for me to leave.
It draws you back. Once it's in your blood, it's hard to dismiss it or forget it, and it just woos you back. And so I decided to come back to New Orleans and open up a small law firm with my best friend from high school, who is actually ended up being the former sheriff of New Orleans, Marlon Gusman. At the time, he was one of Dutch Morial's key figures in his administration. And so we opened up a law practice, small law practice. And from there, I eventually went to a medium-sized law firm in New Orleans. I was also, in the interim, a deputy city attorney for the city of New Orleans. At the time, I was just trying to reestablish my career and establish myself as a practitioner in New Orleans. And so I did that for a few years. And then,
Was it if you don't mind me interrupting, was it a difficult transition going from practicing with a Wall Street firm to then coming here to New Orleans, or was it fairly straightforward?
well, a few things in life are as straightforward when you move from a place like New York City to New Orleans. It's a whole different universe. But in terms of the practice itself, there are certain fundamentals that apply whether you're, in a rural area in Mississippi or if you're on Wall Street. And that just comes down to attentiveness to service and a recognition and reminder of why you are there, who you are serving, what your client's needs are, the skills that are necessary to advocate for that client's position.
Which of those skills do you think, or practices or styles, did you find you had to tweak? Because what worked in New York might not necessarily work here in New Orleans, and vice versa, or not.
Mm-hmm. Well, as you probably know, your style as a lawyer evolves.
Yes.
And my initial formative years, it was premised on a very hard-hitting, aggressive, sort of take no prisoners approach, because there were huge amounts of money at stake in representing largely Fortune 500 companies. So these were $100 million cases, and so that usually required a very, how should I put it, hard-hitting, aggressive style, which doesn't necessarily mesh with my personality.
Okay.
But I, adopted some of that, I must say. But it transformed ultimately into just advocacy and remembering that I'm there to serve that client. So it doesn't matter if they were General Motors or Shell Oil Company. The passion and the advocacy was as important when you're representing some individual who may have their life savings at stake in litigation, or custody of their child at stake in the litigation, or their very freedom if they're being criminally prosecuted. And frankly, once I started representing those kinds of folks in those normal situations, I found that far more inspiring than whether a Fortune 100 company would beat out another Fortune 100 company for $500 million that was in dispute. And I distinctly remember my first custody case with representing a single mother and the trial of that case. That was more pressure, more passion that I mustered in that effort, more at stake than the largest cases that I worked on in New York City. Getting custody of that child for that single mother, to me, was a life or death situation. And so the passion and the hard-hitting adversarial style, which doesn't mean, by the way, being a jerk. It doesn't mean diminishing others. It doesn't mean letting your ego control the situation to lift yourself up. It means a passion for serving the interest of that client, however small it may be in the larger scheme of things. So the hard-hitting style actually served that purpose. But you should always do it with dignity and respect for the institution, respect for the opposition, respect for the judge, and respect for the process. So those are the lessons that I took from that experience in New York.
Out of curiosity, when you transitioned from New York to New Orleans and you were practicing law here in New Orleans, did you find that there was a difference in how lawyers treated one another from New York City to here? Or it was pretty much the same? You know, most of the profession are professionals and they treat other respectfully, and there's always a few jerks out there. Or did you notice there was a huge cultural change practicing law in New Orleans than practicing law there, and how you interacted with opposing counsel?
Well, not a significant difference. There may have been some sort of demographic sort of nuances in the way that lawyers in the South interact with each other. It may be a little bit more genteel. It may be a little more down to earth. But, you know, once the bell rings,
two tenacious opponents at each other.
Yeah, which is as it should be,
yes.
Because you're trying to advocate for justice and to reach a just result with usually two competing narratives
yes.
of what happened. And so that's how our system works, with that zealous advocacy, which we are duty-bound professionally to actually deploy in our representation of others. So, you know, I found that once you start that adversarial process, it pretty much is the same. And there are good lawyers wherever you are.
Yes.
I don't care whether it's the country lawyer or the big city lawyer. Good lawyers can be found. And we certainly have some of the best I've ever seen in New Orleans. And some of the best actually graduating from this law school.
Hey.
And we could talk a little bit about why that is in a minute. But the big law firms in New Orleans were every bit as capable as the big boys in New York City. So not a lot of difference there.
Well, what inspired the shift from the practice of law now to the teaching of law?
Well, it was quite fortuitous. I was attending a Federal Bar Association function, and I ran into the then dean of Loyola Law School, Louis Westerfield. And we just struck up a conversation, and he asked me, have you ever thought about teaching law? And I said, no, I really haven't. Tell me about it. And so he started describing the job. And at the end of that conversation, I said, wait a minute. You're telling me you are going to pay me to teach, to think, and to write? And you call that a job? And you're going to compensate me for it? Where do I sign up?
Yeah.
So that caused me to embark on how do you get into legal academia, which is quite a competitive area. It's very, very difficult because these jobs are so coveted.
Yes.
And there's some really incredibly talented people applying for them. So I came to Loyola and did the job talk, and I was fortunate enough to get an offer. And the rest is history. That was back in 1991. I can't believe I'm so fortunate to have landed in a situation like this. I consider it better than winning the Powerball, even the most recent Powerball. So yeah, it's just a wonderful opportunity to help influence and shape the lives of young people, and to contribute to the betterment of the profession.
For the listeners there, if you're not picking up on it in Professor LeCesne's inflection, I can tell you he's speaking very passionately. I see the smiles coming out when he's speaking of the shift to teaching and the intensity in his eyes, and I can really see he digs this stuff.
Well, passion is important in whatever you do.
Yes.
Whether it's cleaning your toilet or arguing before the Supreme Court. You do both of those tasks as if the world were watching.
Well, in teaching, do you find there are any differences from your experience being at one of the Ivy League schools to teaching here in a small Jesuit institution?
Yeah, absolutely. There are major differences in that regard, especially at a Jesuit institution founded upon Ignatian principles, which center around service to the underprivileged and a commitment to social justice. That's one thing. The other thing is this Ignatian ideal, which is referred to as cura personalis. It's a Latin term that means a holistic respect for and cultivation of the individual parts of every person, recognizing and respecting with dignity what each of us are made of, which are very unique component parts. And that involves our lived experiences, our identity, our racial identity, our social identity, our ideological perspectives, our religious orientation, just respecting all parts of the individual. Those things are incredibly important in shaping a community. So at Columbia, one of the best law schools in the country, but there was little sense of community. Everyone was kind of like doing their own thing. Most of these people were destined to end up in the pinnacles of power, whether it's governmental or private sector. And so they were enormously talented individuals, but there wasn't really a sense of community that you'll find at a small Jesuit school or any smaller school that has a mission, an identifiable mission. And if that mission centers around service to others, that permeates the whole campus and it attracts a certain kind of person, a person who is aligned with those commitments. And that helps shape a community, one where everyone feels interconnected, where they feel that they belong, where they feel that they are striving towards a common objective. And if that objective is aligned with supporting and uplifting others, that makes for a special place. Now, not everyone that comes to Loyola has that mission in mind, but inevitably it affects everything that we do here because it just permeates the place. And it makes for a very comfortable environment where you are poised to thrive and to learn and to do your best because of community. Community is very important in a recognition of our interconnectedness as beings. It's very important. And so, not allowing ourselves to drift off from that interconnectedness and just kind of do our own things regardless of how it affects others really shapes the experience. So there is that. And in terms of just the quality of students, we in New Orleans at Loyola and smaller schools throughout the country have incredibly talented students. Now, the students that you might find at some of the top-ranked and Ivy League schools, those are students that have excelled in college and standardized tests. So these scores that they come into, these entrance credentials, are off the charts, right? We don't have as much of that at Loyola, though we have those who have objectively performed well. But that's just the starting point of one's capacity and capability and ability to serve and grow and make meaningful contributions. And what I mean by that is raw intellect is just a tool. It's just one aspect of an individual. But there are many other parts of an individual that could contribute to their overall efficacy in serving others. And law is a service profession. So I would say that the students at Loyola can compete with or even exceed the performance of students at some of these higher end schools, because the strength of individuality and what motivates a person, and the intangibles like passion and commitment and service and kindness and compassion and humility and all of those traits that really elevate our humanity, are not found in LSAT scores
No, they're not.
or GPAs.
How do you, or how have you as a professor, integrated some of these aspects of Loyola's mission when you're teaching? How do you, because I assume you'll go teach your class on torts or civil procedure, right? And you could go the whole hour or however the length of time is, and you're just focused on the law. But I assume you try to purposefully find moments where you can integrate the university's mission into what you're teaching. How do you go about accomplishing that?
Well,
So you're planting these seeds in students' heads, our future litigators and advocates.
Well, that's a very good question, and it's never just about the law. There is a saying, and I forget who the person is that said it. I think it was a saint, actually, that justice without a spiritual foundation is incomplete. So I constantly remind my students that, first of all, you are learning a service profession. You are here to serve your clients. And so it's not just about doctrine or theory. You are learning skills to effectuate a result that is going to be life-changing for your client. And so always remember that. It is not about you, so drop the ego. Although how you conduct yourself in practicing law says a lot about you as an individual. But remembering that it is result-oriented in service to your client. And when you remember that and constantly remind yourself of it, then you're in the best position to do what you were meant to do. So let's talk about how do we get the result for your client given this particular principle of law or this particular case with which we're being confronted. Also, look at the human components of the case and the litigants and their lives, and how does the principle of law that is being discussed respect the individual dignity of the persons and creates policies that result in a better community and a better society.
One reason I ask this is, as you're aware, for over a couple of decades, I served in the U.S. Department of State's Bureau of Diplomatic Security. And years ago, we established what we called leadership tenets, and they were enshrined in our regulations. And the idea was to keep those in mind when we were doing the variety of our tasks, whether we were conducting productive operations or security management or criminal investigations. But we were constantly reminded whether we were the subordinate or the supervisor or peers. And then we would also consider this when conducting evaluations. And so this is why I asked the question, how, if the university also works with the professors to remind them, when you're teaching, just like you've been talking about, and from what I'm hearing and having been in one of your classes years ago, I picked up on that integration of the mission. But is the school ensuring all the professors are remembering, hey, we need to make sure we're tying our mission into our teachings, because one can get into a routine, and I just go teach my law class, right?
Yeah, that's the beauty again of a school like Loyola with a Jesuit Ignatian foundation. we don't have to really remind ourselves, though we do it periodically, but the sense of community that is already created by that common mission just infiltrates everything we do. So we're proceeding from an ethos that is already sort of built in to what we're doing. And so we just constantly remind ourselves not that we should be doing it, but how we can do it better.
Yeah.
So we don't have to, it's not a two-step process for us. It's like we're here to do X, Y, and Z. And how can we make that happen in a more effective way? And we do that constantly. There's a lot of collaboration between professors. We talk about how we can make our classes come to life more for our students. Techniques, we share materials, we share ideas. There's a lot of cross-pollination of thought into how to effectively teach in alignment with that mission, which again is social justice oriented. And that has many forms. It doesn't just mean service to the underprivileged, although that's a huge component of it, but we see it come to life in our law clinic. Loyola had a law clinic before law clinics were even fashionable. Now every law school has them, but we were doing it before it was a thing, right?
Yes.
Back in the 60s. And it was and still is a very important part of our mission, where we have students that are learning on the ground, serving real clients in real cases under real circumstances, and most of these clients could not otherwise afford legal representation. So we also do it in our skills courses. We're very experientially oriented law school, where you bridge theory with practice and how to get it done. So we don't just mire ourselves in doctrine, legal doctrine and theory. We take the next step and train our students as to how to do it. And we do that through our clinic, through our skills programs, through our robust moot court and trial advocacy program. And we just believe in learning by doing.
From what you've been able to, before I forget, because this question came to my mind while I've been listening to you, and it's here within New Orleans, so without having to comment on Louisiana or across the U.S., here in New Orleans, from what you've been able to observe from the time you were practicing law here to now the last 34 years of teaching, do you find that the profession has maintained standards, or has there been a loss of professionalism over time, or has it actually improved? Are we doing things better as legal practitioners in the court system here in New Orleans?
Well, I don't know that it's unique to New Orleans, but unfortunately, I sense more of a diminishment in professionalism and attentiveness to professional standards. Maybe that's a result of the over-commercialization of law, with the prolific advertisement that we see, with the increasing competitiveness for clients, with the degradation of legal systems and not honoring the rule of law, which in turn is probably a product of more politically based judicial appointments. And that's why I emphasize how it's important to honor the integrity of the process and the system. And however politicized we get in our engagement in other aspects of life, and we're overly politicized and we're incredibly divided, and that's not a good thing. Some of that has seeped into the legal system. So I think there's more of a tendency to cut corners. There's more of a tendency to push the envelope in terms of credible legal theories. There's more of a temptation by judges who have a politically oriented center to achieve a result that's inconsistent with the rule of law. All of these things degrade the process, degrade the system, and degrade our humanity. So it's important as officers of the court to honor the process and the systems and to do so with integrity. What's the solution for that? Well, one potential solution, I think, is more robust imposition of sanctions against attorneys who abuse the process. And that's one thing that I think is underutilized that might serve to nudge us back in the direction where, it is more of an honorable profession than it is today. I still think that lawyers serve an extremely important function in our society, and it pains me to see the process and our institutions degraded to that extent, where politics starts to invade the process of obtaining justice.
Speaking of politics, well, here in Louisiana, and it happens in other states as well, but a difference between the way judges become judges here and in the federal system. Judges here are elected, and in the federal system they're nominated and confirmed and appointed. What's your take on it? Is one necessarily better than the other, or it's good that we have two different systems where you got to be elected into it and voters could throw you out later, or should we consider having judges serving for life at the state level?
That is an age-old question that has plagued the legal profession from the dawn of its inception. There are
many ways to skin a cat.
there are downsides to each system.
Yes.
With the electoral process, you're subject to the whims of the electorate, which can be easily manipulated, and depending upon who has the most resources in that electoral process, can result in someone who maybe is not best suited to be a judge. On the appointment side, you have the same potential corruptive effect by those who are appointing judges. And that's why I don't care what side of the aisle you're on. If you are a part of the administration of justice and a part of our legal system, as a lawyer or a judge or as one who appoints judges, you need to honor the process. Now, inevitably, some sort of political ideology will seep into the process to some extent. And that's unavoidable because we're all human, and we'd like to, if we're in a position to appoint a judge that is aligned with our values.
Yes.
But our values have become so corrupted and has strayed so far away from why we're all here on this earth in this temporary situation called life. I believe it is to uplift each other, not tear them down, not to engage in deliberate cruelty, not to subjugate those who are vulnerable, not to try to acquire for ourselves wealth and power to the exclusion of others, not to honor and respect basic human values and the humanity of each other. When you start straying away from that and trying to sort of load the dice, you dishonor the system and you weaken the system, and you can weaken it to the point where it no longer serves its fundamental purpose of achieving justice. And none of us win in that situation. So whether it's appointed or elected, we've got to come back to honor and integrity and compassion and kindness and love. I know it sounds trite, but we actually do better for ourselves and for others when we manifest a loving heart in all of our actions, regardless of those with whom we disagree. It should never get to the point where we're willing to tear each other apart or where we normalize the deviancy of dividing each other based on ideological or political or other human traits, which we all have, that most of us are not responsible for, or were brought into this world with. I mean, the color of your skin, or how you were raised religiously, or what you believe in, all of these are products of our exposure and our experiences. So how can you fault another person for having those perspectives? How can you diminish and dehumanize them for being what they are? Even if you disagree with them, even if you think they're the most vile individual in the world, you still should respect their right to be. And if we just respected each other's right to be, we can make a lot more progress in being in a world where we can all thrive.
This is true, and you reminded me of, there's a book that I enjoyed when I was in high school called The Once and Future King, and it's the evolution of Wart into King Arthur. And he goes from an environment of where might is right, and he's trying to switch the message to right is might. And so as you were talking, I was thinking of that. And speaking of the system of justice and kind of focusing on where you've been specializing, for lack of a better expression, over the past few years, the area of tort law. For our listeners, tort law, tort comes from Latin, and it involves an injury of some kind. And we generally think of personal injury as sort of your ambulance chasing attorney. Been there, done that. But it's more than just that. I mean, people have suffered a harm. They could have been part of just a traffic accident, obviously, or they could have been working on a job site, or it could be something much even larger than that. So walk us through one of your experiences or lessons that you've focused on involving tort law, and where we go from instances, and as I alluded to at the beginning, are these truly accidents, or well, it's ordinary negligence, or are we dealing with wrongful misconduct, and what that means?
Yeah. That is a huge question, which we could talk about literally for hours. But let's just see if I can just cut to sort of the general parameters. Torts, as you identified, really deals with injuries to persons and property. And it's so much more than just the proverbial ambulance chaser.
Yes.
It's any injury.
Defamation is a type of tort.
It's a reputational tort. Your reputation can be harmed just as much as your limbs could be harmed in a physical accident. So all of these are compensable, potentially compensable events under our tort system. And the tort system is a way of, first of all, regulating our conduct so that we know what to expect of one another in our everyday interactions, even if we've never encountered that individual before. The rule of law through tort jurisprudence, court helps us to coordinate our activities so that we are less likely to harm each other, whether it's through inadvertence or more conscious conduct directed toward someone else that results in their harm. In any event, tort law creates the policy, the regulatory policy, to help guide our actions and our behavior, and it also provides a compensatory mechanism to properly allocate who should absorb those losses. When you're physically injured, someone has to pay for it, right? Someone should it be the victim, or should it be the putative tortfeasor? That's what the tort system of law is designed to determine. Who should properly bear that risk of loss? And so it's incredibly important to society because, again, without those regulatory principles, we would really not know how to order our affairs. you know, it is concurrent with statutory regulations. For example, the traffic code. Right?
Yes.
You know, you have to adhere to certain driving requirements, and if you violate them, you are statutorily sanctioned. So that is one regulatory scheme that affects how we conduct ourselves on a highway. Imagine if there were no traffic laws and everybody could just do their own thing. You'd have mayhem, you'd have chaos, and you'd have unfair absorption of losses caused by the wrongful conduct of someone else.
Deregulation to the extreme.
Yeah. So we have statutory traffic laws, but we also have jurisprudence, torts jurisprudence, that also specifically direct what the expectations of reasonableness, of reasonable conduct should be when we're engaged in driving. That's just one small example, but it cuts across all aspects of life. And without that regulatory fabric, and again, it's both the statutory as well as the jurisprudential, we're better able to at least I shouldn't say minimize, because there's still mayhem and destruction that's going on. It'd be that much worse without this regulatory overlay. But what these regulations do, both statutory and jurisprudential, is provide a disincentive to act unreasonably and cause harm to others. So that's the overview of what tort law is and what it's designed to accomplish.
And for our listeners out there, the value of attorneys that are practicing tort law, the personal injury attorneys, and then the ones on the other side, the defense attorneys. Share your insights about that, the value that each brings to the table. And you've alluded to that, talking about identifying, actually who bears the compensation for the harm.
Mm-hmm. Well, in most tort situations, there are in every tort situation, you're going to have someone who was victimized by the behavior of someone else. In other words, they've suffered some sort of loss as a result of another person's actions, whether they were wrongful or not. They've suffered this loss. And then on the other side, there is a competing narrative of who was really responsible for that loss to begin with. Maybe it was the plaintiff, maybe the tort victim.
Yes.
It wasn't me. I behaved in a reasonable manner.
Yes.
And so we have or it might be some third person or some non-party to the case or some co-party to the case, another defendant who, it wasn't me, it was that person who was responsible for whatever happened to the plaintiff. But we need a process to sort through all of that, and that's our adversarial litigation process. So it's easy to malign the tort lawyer thinking in a limited view of them being an ambulance chaser or whatever until you need one,
Yes.
until you've suffered some sort of loss that should not have happened because of the behavior of someone else. So we have an adversarial process where we can sort through that, and whether it's a judge or a jury, they will determine whether the expected standards of reasonable behavior in that situation was adhered to, in which case the defendant will be absolved of any liability, or whether it was breached, in which case the defendant and maybe even the plaintiff, if they contributed to their own harm, would be responsible for those losses. But that's the process. Otherwise, how would we decide it? In England, before the founding of this country, it was decided by somebody with a crown on their head, and that was not always the best result, even if you could get before that figurehead. So we've developed a system of justice in this country, and it's an adversarial process where the truth of what actually happened is determined by hopefully an objective tribunal.
And what about when the harm is committed by an individual or an entity that has the protection, the blanket of immunity? So whether, it's a municipal, state, or even the federal government, how does one hold those individuals or those institutions liable? Because they have things known as qualified immunity. And I find, a lot of times, at least from my observations, that it's very difficult to do, even when one can demonstrate there was a harm committed.
Well, that's a very good question. And it also helps shed some light on the notion that not everything that befalls you of an injurious nature is compensable. There are immunity grants that run across the spectrum of our institutions. One, as you've mentioned, is qualified immunity for municipal, state, and federal governments. That's a trade-off. It's a trade-off because those institutions also perform invaluable services to society. So they are endowed with a certain amount of protection from and shield against being held accountable for every misfortune that might happen to someone who encounters those institutions, because otherwise those institutions would not be able to function as a matter of resources or being overwhelmed with lawsuits.
But do you think so? Now that you have, again, several decades of experience in having studied this, so again, some people argue, and I, having worked as an attorney, having worked as a federal agent, arresting people, conducting operations, whatnot. So some people make the argument, say whether it's a state level or federal prosecutor, well, if they don't have immunity, well, they won't be able to do their job.
Yeah.
But then again, well, is that really true? Because one could say, well, look at doctors. I mean, they take people's lives into their hands, literally, day in, day out. Yet it hasn't impeded their ability to deliver a service. Yet they can be held accountable should they not meet the standard of their profession. So now, is it time for perhaps we examine the question of immunity for government officials?
The simple answer to that is absolutely yes, because as with all any sort of doctrine or institutional protection, there can be abuses. It's a delicate balance, and I think you're right in identifying that the shield of immunity has often become a pretext for abusing the rights of others. And yes, but again, that comes back to honoring the system and enforcing the laws. Because if it's outside the bounds of immunity, it should not fall. That protective shield should not be there. But even doctors, have a certain amount of immunity, depending upon the exigency of the situation with which they're confronted. But yet they are still held to a standard of care. Not so much on the governmental end. It's a much broader grant of immunity, and bad actors take advantage of it. And so I think absolutely you're right. But I do think there is a place for limited immunity that is enforced with integrity and honor and not abused.
Because I never felt in the exercise of my profession as a law enforcement security professional that I couldn't do my job if I didn't have immunity, because my focus was always on, as I like to communicate to those I worked with and that I would lead, it's unquestioned integrity. Do we have sufficient evidence that would lead us to believe this individual has committed a crime. Well, let's put that together. Is there any exculpatory evidence that we need to also consider? And then pursue the individual subsequent to obtaining an arrest warrant, getting that, executing it, but never, and I don't know if this is an outcome of my education, my upbringing, whatnot, but again, I never had it in the back of my mind, well, I can do what I want or make mistakes because I have immunity. And I would think, and I hope no one in the government profession thinks that way, because that just leads itself to abuse, and not necessarily intentional abuse, just abuse through negligence, right? And so that's why I wanted to bring it up, because there are many instances where you have government actors and they end up harming individuals just through sheer negligence. And I don't know, I mean, over time I've thought, well, they should be held accountable in some fashion or other, because sometimes it really doesn't happen on the inside. And whereas I think if there was that specter, that cloud of, I can be held financially responsible to that victim if I didn't adhere to a standard of care, that changes the equation. But I find the bar can be so high when you have a government defendant for the plaintiff.
Yeah, well, your view towards doing your job in the right way is a product of how your parents raised you, right? Not everyone has parents as diligent as yours. And so others take cover for their unreasonable conduct under the pall of immunity. But, it's hard to determine when that line is crossed. But the abuses unquestionably occur. And you're right. It should not, if you're doing your job right, you should not have to worry about whether or not you exceeded the bounds of reasonableness in your actions. And so you should not have that cover when you do exceed those parameters. But on the other hand, like anything else, it's a delicate balance. It all comes back to the person who's implementing it, and honor for the system. There's a certain immunity granted to law enforcement under our Constitution and our constitutional rights in terms of search and seizure and the requirement for reasonable suspicion and probable cause. But when you have corrupt judiciary that is misinterpreting what reasonable suspicion is, then it just opens the door for corruption. The most recent example is the U.S. Supreme Court saying that you can stop a person based upon what they look like in immigration enforcement. That is an abomination and just a complete defilement of the constitutional requirement of reasonable suspicion. So again, it all comes back to who is doing the interpretation, who is doing the implementation, who is enforcing the laws. But if you take a qualified immunity as a principle in and of itself, it does serve a purpose. But the fact that it is abused and exploited and used as a pretext for wrongful conduct does not mean it doesn't have a place at all.
I've been playing catch up with a lot of the decisions coming out of the Supreme Court, and I'm aware of some of the latest ones. The one thing that just kind of resonates with me is I had found it interesting that earlier in the year, when the Supreme Court was basically stating universities cannot use race as a factor in their admission policies. And again, whether one agrees with it or not, to me, I found the thing didn't follow. The non sequitur of this was, well, they can't use race in their admission policies, but then now we're saying race can be used in, law enforcement operations. So I just found that a bit of a contradiction. But granted, that's a discussion for exploring those particular cases and looking for, the nuances. What are there differences in how they're approaching race, Or are they literally contradicting themselves and they haven't realized it?
That's an excellent observation. I hadn't thought about that particular contradictions because the contradictions are so prevalent in everything this Supreme Court is doing. Because again, they're looking at what outcome, usually a politically, ideologically based outcome, they want to achieve, and they just sort of back themselves into it and discard decades of jurisprudence from their predecessors in order to achieve that result.
I'm kind of curious if even the attorneys that were, arguing for not the use of race by law enforcement, and that was recently decided upon, if that was even brought up. I wonder if the lawyers even mentioned that to the Supreme Court. Well, if you say race can't be used over here, then you definitely shouldn't be using it over here, because now it involves a denial of freedom, right? But again, that's a very deep discussion.
I love that topic. That's one that maybe we can circle back to.
How do you find that tort law education and practice have evolved, and do you see areas for improvement in tort legislation?
Oh, yeah, I think, well, let me start with just the principles of tort law. They are pretty solidly enshrined in our tort jurisprudence. I'm actually using the same case book today to teach torts that I had in law school. God, it was so long ago.
I hope it's been updated.
It's been updated, but we're reading some of the same cases that I read in law school, like Postgraph.
Okay.
Right? There are certain immutable principles that stand the test of time. So, but those principles evolve as they should, because the law is an organic process, and it changes to meet the changes that we see in society. We've become a far more complex society, much more populous societies around the world, much more highly populated. The more people you put into a given place, the more prospect for boo-boos that can happen, right? And so that hasn't really changed much. But how we get to effectuating justice, resolving these disputes between those who are harmed by the conduct of another and those who are being accused and called to repair the harm that they have caused. Some of the major, I think, advances over the last couple of decades, certainly I would put the advent of comparative fault is one of the major things. And by comparative fault, for those listeners who are unfamiliar with that, in a tort case, most states have adopted some form of comparative fault, so that the fault of all those who are responsible for the plaintiff's injury, including the plaintiff themselves, because sometimes the plaintiff is contributorily negligent in causing their own harm. With comparative fault, the allocation of loss is distributed amongst all of those who may have had some role, however large or however small, in causing plaintiff's injuries. So it's sort of a you broke it, you fix it approach, right? Before comparative fault, we had the situation where if the plaintiff was even a tiny bit at fault compared to the defendant, they could not recover anything at all. And that led to some unjust, inequitable results. The plaintiff could have been maybe only 2% responsible for their harm, and let's say the negligent, drunken driver going 100 miles an hour on a city street would, and 98% at fault, would be absolved of complete liability, and the plaintiff left to pay for their own losses. So that's obviously inequitable result. So the advent of comparative fault, where everybody who contributed to the harm pays for their proportionate role in causing that harm, that was a big one. I also think the evolution of products liability law has been a major advancement, and allowed causes of action very creatively brought up by the plaintiff's bar, the cigarette manufacturers, for example. That was through the creative use and at the time novel use of products liability law to actually hold cigarette manufacturers responsible for the decades of a loss of life that they were caused by the deceptive purveying of their products.
I remember just an anecdote for the audience when one of the litigators came to Loyola Law School. For the listeners out there, I'm a graduate of this law school, and he talked about how one avenue they found for going after the tobacco manufacturers was the way they would advertise. And because they weren't being, let's say, providing full disclosure about the harms, though everyone could say, well, we know cigarette smoking is bad for you. I don't think people really appreciated the degree to which it was actually supported. Manufacturers knew that they were not only delivering tobacco to smoke, but they were designing their cigarettes as, it was on a microscopic level. It was a delivery mechanism. They knew how much to put of what in there to ensure they had a customer to deliver the effects of the nicotine. But then he alluded to a company, and he actually brought the cigarettes with him, and it was out of the UK. He said, we can never sue these individuals. And the brand, I think it was a black box with gold trim, and the label for the cigarettes was death. And on the side it said, this will kill you. This will give you, terrible health effects. And that's it. They gave full disclosure. So just as a little humorous, anecdote, but it provides perspective in terms of, okay, what we assume that everybody knows, and lawyers are just trying to make money off of this. And I'm sure there was an element of that. But when you start to, like I say, you start to dig, you find out, this isn't like just a regular cigar that they just wrapped, tobacco leaves in. No, it was designed to create addiction.
Who else is going to keep them honest if it's not lawyers?
That sounds a bit of a contradiction as well.
Well, only if you buy the lawyer jokes. But the same thing could be said of the asbestos industry,
yes, or
the automobile industry and their designs of seatbelt restraint systems and inappropriately placing gas tanks in a position on the car where they are more likely to combust in a collision, breast plant litigation, all of these things that are profit-driven enterprises where the enterpriser is seeking to maximize profit, and they do that through sales. So how can they get more product out there? How can they put those products out there at a less expensive productive cost, which inures to their bottom line? So these are profit-driven ventures that are putting out mass products to which we are all exposed and in a large part dependent upon.
Yeah.
How do we protect ourselves were it not for the lawyers keeping them honest? So when we castigate an entire industry or entire profession that is actually there to serve as a watchdog of sorts. And yes, they are compensated for those efforts, just as a doctor is.
Yes.
In serving healthcare needs. But these are critical functions that without which we would, there would be a lot more inequitable distribution of those losses and a lot more prevalent conduct that creates more losses because they've gone unchecked, unregulated, and without consequence.
And I know from my personal experience, and from what I'm aware of, it's still happening today. One benefit of a tort lawyer is the fact, because they generally operate on a contingency fee basis, this is one areas of the law that even the indigent have access to, because they need not worry about having to pay the attorney.
They do pay though.
They
pay
pay
on the back end.
They pay on the back end, but in terms of an upfront cost, whereas like if you need a criminal defense attorney, it's either provided by the state or you have to pay out of pocket. But generally in tort law, there is recourse for those that are without the financial means. Is that still the way it is today?
Oh, absolutely, and that's the way it should be, because without that recourse, they would have no access to justice. The working man can't pay $500 an hour for a lawyer to take their case, even though they may have suffered a life-transforming injury. So that would mean they were effectively denied access to justice. And so one way to bridge that availability is through the contingency fee.
Yes.
Now, the lawyer who takes it on at tremendous financial risk to their own livelihood. When you think about the huge number of hours and upfront costs that they have to pay for in order to serve that client, even in a relatively small accident case. And so they are compensated at the end if they get the result that, ends up compensating their client. And so they get a portion of that. But without that client, the working Joe, and certainly those with who are in more necessitous circumstances, would not be able to have access to tribunals to award them reparative or compensatory results.
And speaking of the average Joe, and as we're coming here to the conclusion of this episode, now, parting thoughts that you'd like to share for any of our listeners who are law students and will soon be litigators out there, or even for the practicing attorneys, whether they have been just practicing for the last year or decades. What's something that you would like to leave with them?
Yeah, a couple of things. First of all, stay authentic. Stay true to yourself. Don't try to be something that you're not. So that's just in the way you carry yourself, because authenticity is important. Now, hopefully that authenticity will also be grounded in the need to, or let me strike that, in the recognition that you are here to serve others, as I've been saying, to serve your client, not for your own enrichment, not for your own ego, not for your, not to enshrine yourself with
accolades
or egoistic inspiration.
It's not about you, it's about the client.
It's about the client. So remember the service-oriented nature of the profession. And remember that client has entrusted you with the single thing that is the most important thing in their lives at the time. And then you take that sacred obligation with you and you advocate for them with passion. Drop the ego. Whatever you do as a lawyer, do it with humility, with kindness, with compassion, and let those principles guide your actions. It's not about you. It's about something much bigger than you. And those are just the foundational principles that I think apply to almost everything you do in life, but with particular urgency when it comes to representing your clients as a lawyer and to effectuate that precious objective of achieving justice. And so honor that, remember it, and don't stray from it.
I always like to ask my guest particular book that has resonated with them over time, or what they're currently reading, because I find if you want to get to know a person really well, you walk in their shoes, or you eat what they're eating, or you read what they're reading, right? And it also provides new ways of seeing and experiencing the world. So, any particular book you'd like to share with the audience?
Well, there's so much I can
Yes,
talk about with that,
yes.
because I tend to be a hoarder of books. So I will buy a bunch of different books at the same time, and I will graze through them, as opposed to sitting down with one book, reading it from beginning to end. But all of the things that I read, or all the information I absorb centers around health and wellness and spirituality. So if you look at my bookshelf, there's no fiction there. It's going to be Michael Greger on how to avoid chronic disease.
Okay.
He has a couple of books, one of which is How Not to Die. It should be an encyclopedia, a Bible, a nutritional Bible in everyone's life. The epidemic of chronic disease is totally avoidable, and he just walks you through the nutritional plan to avoid the things that we are dying of in record numbers today, whether it's diabetes or cancer or hypertension. All of those things could actually be avoided. So,
is this the kind of book someone like me could actually integrate? Because I'm a hedonist when it comes to food and drink.
Well, I'm a foodie, which is why I turned to maybe I should get some nutritional input. So I'm now a vegan, having read Dr. Michael Greger's book. I just think it's important for every family to be aware of the most important medicine that you can take is what's on the end of your fork.
Yes.
And that will put years onto your life. So I have a bunch of books like
Not
that.
just years, but quality
of life. And the Blue Zones book, that's I find very interesting. The Blue Zones is a book about 7 areas, I think 6 or 7 areas around the world that share common traits in how they live, how they eat, and how they pray. And they have the largest number of octogenarians, people who live, into their hundreds, of any other place on earth. And they're all over the world in disparate locations, but they all share common nutritional and lifestyle approaches. So I've got a ton of books in that vein. And on the spirituality end, I've been reading a lot of Michael Singer's works, one of which is The Untethered Soul. So anything about Michael Singer, I've got a bunch of books on spirituality and mindfulness and meditation. Got tons of books on how to meditate. I think that's critically important to quality of life. And then I have a number of sort of ancient seers and mystics that I read, like Rumi is one that I read quite a bit. I also listen to a lot of podcasts because my diminishing eyesight, I read a ton for law school.
Yeah.
And every class I'm reading 3 or 4 hours straight. And so the diminishing functionality of my pupils, I can only use them so much in a day. So for my own personal growth and edification, I turn a lot to YouTube videos where I can get a lot of information off the internet through talks that have been recorded. Alan Watts is one that I've listened to. He's a philosopher from the 60s that I highly recommend that you just YouTube Alan Watts videos, and it will change your life in a very, very good way. So I get a lot of my information online. It's a rich resource, and I'm not talking about the influencers. That's garbage and poison. But there's a lot of wisdom that you can find if you know where to look in the right places. So I read a lot and absorb a lot online about health and well-being, spirituality, theology, psychology. Carl Jung, the Jungian school of psychology, very fascinating. So all of that stuff. I just, my quench for knowledge and growth outpaces my ability to actually read words on pages, but it hasn't it hasn't diminished my thirst for that knowledge.
It's funny you say that because someone I interviewed recently, when I was asking about what she observed as an element of success of individuals in her particular industry, and what she said, I wrote it down, but I've heard this across the spectrum, and it was the most successful are those who are always willing to learn. And you sharing this diversity of topics, again, I think it feeds into that. Always willing to learn, and I think this is what's made you probably a very influential professor here at the school. I know it influenced me, and I'm sure it continues to influence our future litigators that are out there.
In that regard, there is a quote. I forget who the author of the quote is, but it's something to the effect of, if you're unwilling to change your mind, why have one?
This is true. True. You got to at least be open to it.
You've got to be open to it. Life is too short to know it all. You're always learning up until your last breath. And that learning should be, again, aligned with this compelling need and urge to serve others.
I agree, especially when we're on a large rock hurtling through space, and you start thinking of that as opposed to the tunnel vision we can get, yes.
Yeah.
But hey, I thank you, Professor LeCesne, for taking time out of your day to talk to me and for the audience. Hopefully folks will benefit from this. Thank you to the audience for spending your time with us. A special regards to Loyola alumni, Louisianans, and litigators in general, and to law professors out there. As your host, Maurice Brungart, I welcome you to join us again next week, and that you invite others to also follow Brungart Law's Langyap, where we provide a little extra perspective because the devil is always in the details. Professor, thank you very much.
Thanks again for having me.